everybody. Great to be back. I love this venue and I love this group. So can everybody hear okay? Yeah. Okay, so this is Kate Carlisle from Buckley King. She's an attorney who I'm working closely with because by great fortune, I sometimes can't help all the people who I want to help. And I've asked Kate to join me because she's an awesome estate planner as well, and also has a really great background in real estate law. And she's going to talk a little bit about real estate, so if anybody owns homes or other property planning for protecting that as well. So today we're going to talk about estate and disability planning and areas around that. How many people were here last time in the summer when I did this? Great, lots of people. So we are also going to cover some of the same stuff, but we're also going to cover some new areas, and of course open this session up to all of your questions. So we want it to be very interactive, so feel free to interrupt, and we'll go whatever way the group wants to go while trying to keep somewhat to the subjects that we want to cover in our outline. Okay, and then we're happy to be here for questions afterwards as well. So today we're talking about estate and disability planning. Estate planning and also elder law are my specialties. So estate planning, as you all probably know, is making sure that you are protected and your assets are protected in the event of when you pass away, because we're all going to pass away, right? And, who was it? Ben Franklin said nothing's for sure except for death and taxes, right? So we need to plan for that, and we all know that unfortunately as we age, and also for people who have dealt with their parents, we have the pretty strong potential of being incapacitated either temporarily or permanently prior to the time we pass away. And one of the areas I specialize in is making sure my clients are very well protected. Here and then here, and Kate does as well, if there's a disability, and that's really important. How are we going to protect you? How are we going to make sure you're not exploited? How are we going to help you figure out how you're going to pay for it? And how are we going to make sure that you can stay at home as long as possible if that's what your wish is? So that's all encompassed in estate planning. And then elder law sort of carves out that disability provision and makes sure that we are protecting people if there is an incapacity. And so what I have done in a lot of cases, in guardianship cases where we have an incapacitated person who needs to be protected because there is a known incident of exploitation or the person being a danger to themselves or other, I have a specialty of coming in and representing that person who needs to be protected, who we call the protected person, in a guardianship proceeding. And so I've done that lots of times where I've come in and had to help structure something to make sure a person was not being exploited or to stop the exploitation and protect that person. And so elder law goes into protecting people. It also goes into some of those issues. It, of course, overlaps with estate planning and goes into a lot of making sure that your wishes are going to be carried out if you're incapacitated as you age, and that your resources and your money and your income from Social Security or pensions or 401ks or whatever are protected, and that we're making sure that we get the best tax treatment for all of those assets as well. So that's kind of the broad area of estate and elder law planning in which I'm engaged. It's a booming area, okay, because we're all aging, right? I wanted to share with you a book that a friend of mine wrote recently. It's called Aging with Care, Your Guide to Hiring and Managing Caregivers at Home, Amanda Lambert and Leslie Eckford. Amanda's a good friend of mine. She's a care manager who comes in and can advise me and advise my clients on making sure they're getting the greatest level of care. And she's written this book all about how to stay at home and how to hire caregivers and make sure you're protected. So one of the things that I do is work closely with people like Amanda, who's a social worker and geriatrician, to make sure my clients, and Kate does this as well, to make sure our clients are protected by bringing in third parties who know what's going on with the Medicare system and Medicaid, and who the good doctors are, and what the good facilities are, and when it may be time for me to consider if I've got dementia, or if I've had a stroke, when it might be good for me to consider going to a facility, and what facility that might be, and what facility it should not be. Okay, so part of the estate planning and disability, and I'm jumping forward in the outline now, but is to make sure that we as attorneys work with your other team members and who that team should include. And so this book is available, and they've been having book signings, and I think you can get it on Amazon as well. So that's an overview of what estate planning is, and the importance of a proper plan is to make sure, so when we plan for people, we're making sure we hear your goals and we understand your situation so that we can carefully cater our plan to you. So we want to make sure that your wishes are carried out, that you have control over your decisions. And so that's your medical decisions, and I passed out a Utah Advanced Healthcare Directive, which we have all of our clients fill out, and we walk through this because there are some different options. And also financial directives in either a will or a trust to make sure that these are my goals. I have 3 kids and a husband. I want to take care of my husband. We want to take care of each other, but upon the death of the second of us, we want to help our 3 kids. And one of them is a recovering addict, and I'm worried that he's going to blow through his money, and he's got a kid, and they both live with me, and how am I going to take care of my granddaughter? And so these are the issues that come up regularly for us, and every single one of you is unique in your family and your friends and loved ones and your pets, because they're important too, like Fritz. These guys love the pride and joy of their life. And my Chihuahua and Black Lab. And so we take into consideration everything, and a good planner should do that and then nail down a plan that's specific to you and get everything protected financially and medically. Okay, so those are the important parts of your plan, and everybody needs one. Okay, as we age, and in this book, the authors talk about the geriatric tsunami that is hitting our country. And so I'm 55, so I'm kind of at the very end of the baby boomers. And I see that you guys, some of you people are a little bit more older, but in that same group. We are coming, right? We're here, and there's a lot of us. Okay, and our system's going to have to deal with that, okay? And, it doesn't look like it's really going to very well prepared for that. But what you guys can do is do your proper planning, and you're here, so you're being proactive to make the best of that situation, okay? So that's sort of the intro to why we need proper planning. We also want to consider taxes planning. Yes?
Could you please write the name of the book on the board?
She asked if I'd write the name of the book on the board. Okay, so in any event, that's kind of the intro of the importance of this subject. As you can see, I'm very passionate about it. We like to consider ourselves kind of as mother hens protecting people. And I'm going to turn the time over to Kate, and she's going to talk a little bit more about the difference between a will and a trust, and the importance of planning around real property as well. And then I'll write this name on the board. Stop us if you have questions.
All right. Is that volume okay? Hi, everybody. So I'm going to talk a little bit, Laura laid the framework to being very thoughtful and sharing and communicating your goals and what your family dynamics are, and your children and your parents and your dependents. And so I'm going to talk about taking all of that thoughtful information and putting it into the document. So I'm just going to cover a couple of different vehicles, and they're the most basic vehicles. So the first, which everybody typically knows, is that will, okay, that last will and testament. Now, just real quick, if you don't have a will, what happens if you die? Well, it goes according to our Utah statutes and through intestate succession and to a planned framework of people automatically when you don't have a will. So when you have that will in place, and that will is basically a contract. I mean, you have a testator, the creator of the will. It's got to be in writing in Utah. There's a little caveat, but I won't cover it today. And there's got to be 2 witnesses. You've got to be 18. And you express in a minimum way, it's for simplistic planning. So you're going to cover very basic, who do you want to have act as your representative, and who do you want to have take your assets and possessions upon your death. Maybe you put a guardianship provision in it, but it's very simplistic, okay? So that will is then probated. When you die, we're going to have to take that will generally, depending on who you're sending your assets to and the amount of your estate, to a court, file it with the court. So you're immediately right there. You have additional costs, you have delay, you have judicial oversight. A court and a judge is going to oversee that probate process. And, in addition, of course, you lose privacy. And one very important item is because it's in a court, it's susceptible, there's more susceptibility to an attack, to a contest, to somebody challenging your wishes that you've put in that will. Okay, so that is the will vehicle. Now there is a very important mechanism to fit the will with what I'm going to talk about next is the joint, or not joint necessarily, it could be individual or joint, but a revocable living trust. So that's another vehicle. You still have to have the will, okay, and we'll get to it in a minute, but that type of a will that puzzles with the trust is called a pour-over will. All right. So the idea with the joint revocable or with the revocable trust is that also is a contract. Okay, it's just a contract under Utah laws, contract laws. It's between a trust maker, alive and well, you create your trust, and a trustee, often yourself, the trust maker, and you designate beneficiaries in that trust. Now, a lot of people think, if I put my assets in a trust now, I'm going to lose control over them. I don't want to lose control over my assets. Well, that's incorrect. When you create a trust, you still have complete control over those assets. You're acting as the trustee, but you're allowing yourself to put in lots of rules and expressions of your desire about when you're alive and well. Then, right, because you're going to put the idea is you're going to put your assets and fund the trust now. You're going to put your home in it now. We're going to do a deed into the trust, the cabin, your bank accounts, other assets. And so you're going to be controlling those assets now while you're alive and well, but then you're also going to be controlling those assets while you're disabled and incapacitated. And you're going to set out the rules of how you want to be taken care of while you're disabled and incapacitated. You're also going to set forth who's in charge of that when you can't be in charge of it for yourself. You can't make those decisions for yourself, but you have a loved one that you want to have step in and make those decisions for you. Okay, so the trust serves the purpose of when you're alive and well, when you're disabled, and then, of course, when you pass. Now, when you pass, it becomes irrevocable. Okay, so up to that point, at any point, you can change the trust, revoke the trust, get rid of it entirely. But when you die, it becomes irrevocable, and now that successor trustee or trustees step in and they administer that trust and they take that property where you want that property to go and when. Yes?
Could you repeat what you said about how to avoid probate?
Sure. So the main way to avoid that probate filing is to utilize the revocable trust vehicle. You set that contract in place now, get a trust in place now, and you fund that trust. Big step. Everybody misses that. So many people miss that. They don't put anything in the trust. Now, what if you don't? What if you set up an empty trust and you forget to put everything in? You catch it with the will, the pour over will. It pours the assets over to the trust. Okay? Yeah.
The term, but there's another will where you can avoid probate if you can find an attorney that will do.
Yeah, so if there's some other will mechanism that would allow you to avoid probate. And so I don't, yeah. So for real estate, our state legislature, I think this is what you mean, our state legislature just passed a law that allows Utahns to transfer real estate on death. Okay, so I'm thinking that that's the mechanism. No, okay, but that is a mechanism that we now have at our available to us, really countrywide. It's been in place in many states. So that mechanism is it's like, in a way, when you start titling bank accounts payable on death. It's like when you designate a beneficiary on certain assets. You're designating a beneficiary or a group of beneficiaries specifically, you know, Kate, Laura, Jim, not a class of people to take upon your death. You file that with the county recorder and it automatically transfers the property. It's very new and there are a lot of problems with that device that are still getting flushed out, as you can imagine, with new law. But that is a device to avoid probate.
Do you want
Okay.
to talk about that now, what you see with that?
Yeah, so, you know, there are some real fundamental, so I'm married, my husband and I decide to transfer our property on death to our 3 kids, okay? My husband and I both signed this transfer on death deed. So one of the main problems is, well, what happens if my husband and I get disgruntled, break up, and I revoke it? Do I revoke his transfer on death designation? No. So, you know, what happens then? Is half of the interest revoked and half of it stands? Okay, so there's one issue. Another issue under the current legislation is that this is deadly, I don't know why they wrote this in, but a later executed will changing the designation of the real estate does not alter the transfer on death deed. So if my husband and I, same scenario, put the transfer on death deed on the record, and then we get later we do a will, we forget. I don't remember that. I worked with a lawyer. I don't know what the lawyer did, right? Hopefully they explain it. And then we later do a deed and decide, you know what? Our 2 children here are completely set, but our 1 child isn't. And he wants the family home. And we transfer it through the will to that child, doesn't trump the deed. So now you've got a conflict between the intent with the deed, transfer on death deed, and the intent with the will. And then there's another issue also involving creditors. In Utah, there's a pause period. You know, when you die, and this is an issue with probate, you've got to give usually notice to creditors that you've died, and there's a period of time in which creditors can come in and make a claim. Well, that same concept is carried forward with a transfer on death deed. If I put a transfer on death deed on the record and die, you've got to wait, I think it's a year under the new framework, in order to let that claim period go. Well, many people who inherit land want to sell the property right away. They want to list it and sell it, the kids do. So that's a problem. So it'll take some time before it flushes out. It really will. And actually, a lot of states around the country have gone away, changed their law. They started out as transfer on death deeds, a conveyance, and they've gone to an affidavit, just an expression of intent. So we'll see. So I've covered then the will and the trust, and just a little mention, as people are always very concerned about taxes, and just if you don't know the number, the current number is that there's no federal estate tax for an individual estate now that is less than 11.2 million. Okay, so that's why Laura, and in particular Laura's expertise, which sits in disability planning and needs-based planning, is so critical, because that is what you put in that trust that so carefully handles how you want to age, how you want to be treated, and that is really the meat of what is in that trust. Yes.
Does the property go into the trust? Does the LLC go into the trust? How does that get handled?
Yeah, so They'll vary in how they do it. Sure. So she asked if you own a piece of real estate and you have that real estate titled in an LLC, very prudent to do because of liability protection, how does that dovetail into the trust, into the estate plan? And so the way I tend, unless there is a tax reason not to do it, I tend to advise that we have those limited liability interests, they're called membership interests. Those are held then by the trust. So you still have your land, you have your LLC protection, and then the owner of the membership interests is the trust. Okay, if not, you've got your pour over will. If you don't put it in the trust, you don't get those corporate shares or membership interests titled in the name of the trust. You've got that will. Going to have to probate it probably, right? But then we're going to get those membership interests right into that trust. Okay.
Just to follow up to that too, sometimes what I will do instead of having the membership owned by the trust, we just do an assignment on a piece of paper that says, I'm assigning my rights of this LLC to the trust in case I die or become disabled, and thereby allowing the trustee to manage it. And if that's a LLC that just has like you and one other person as a member, that will work as well. Okay, another question here?
One is, do you recommend putting getting a TIN for the trust?
Okay, first question is tax ID number or an EIN, TIN for the trust. The answer is no. With a revocable living trust, the kind of device that Kate explained, where you set it up and then you can change it any way you want, that has all of its tax reporting under your Social Security number. So that's the tax ID number for the trust as long as you are alive. If you pass away, then typically the estate needs to get a new tax ID number because your Social Security number dies with you unless somebody steals it and goes, starts charging things in Russia or something. But at that point, we can't use your Social Security number. Does that answer your question?
Yeah. Is it recommended to take care of that beforehand so that your family members aren't having to do that?
The question is, would I recommend that tax ID number that we're going to use after you pass away ahead of time? And the answer is no, it's not really appropriate to do that ahead of time, because when you apply for the tax ID number online, which you can do with the IRS, and we do all the time, you have to give a starting date for when that number became necessary. And that's the date that you die. We don't know that yet, typically.
Run into problems with doing it prior to somebody dying, who's been in banking for 25 years. So there's lots of mixed answers, and it seems like I get a lot of them that do take care of it before and just run the trust under that tax ID number.
Okay, so the question is this and says she's seen some confusion with banks as to what is the proper tax reporting number for assets that are in a trust. And so you need a tax reporting number if you have a bank account that's earning interest, right? As you guys know, at the end of the year, your bank wants to send you a 1099 showing what the interest is. And so it is confusing because there are some trusts that are irrevocable. So for instance, I've set up a trust for I've got a nephew who's got autism, and we've already set up a trust for him. He's alive, and that's an irrevocable trust. It can't be changed. Because it's irrevocable, it has to have its own tax ID number. So when we went into the bank on that, we said, hi, this is the Milliken Gray Special Needs Trust. We need to set up an account. We've got some investments at Vanguard, and we keep putting a little bit of money in all the time. And that is under the tax ID number that we got for that trust, because it's not controlled by my handicapped nephew. It's controlled by us as the trustees for him, and it's an irrevocable trust. And so if I go into the bank and get a bank account at Vanguard, which I also have, in the name of my revocable living trust, that account is tied to my Social Security number. And so banks often get confused because people are confused as well. And so what we do is we give our clients clear instructions on, you know, when they go into the bank on what the proper tax reporting number is. But it is, you were right, it's often confused. But if you start getting a tax ID number when you don't need one, you are very quickly afterwards going to get a letter from the IRS saying, hi, why isn't this entity for which you have a tax ID number paying any taxes? Nobody wants to get that kind of letter from the IRS. Then you got to write them back and say, well, I don't really need it. I got it only because I was going to have it for when I die. And they're like, no. Okay? So
I just want to mention, I work with a large title company and have for 20 years, and I've seen thousands of times people that come in and say, well, the lender wouldn't lend to us as trust. You know, you go in and get just a very simple home mortgage. The lender won't lend to us as a trustee. So could you do a deed to transfer the property out of our names as trustees back to our names as individuals? We'll put the mortgage loan on. And so I always say to people, yeah, I mean, you can do that. But I always say to people, make sure you tell your mortgage lender when you go in for a loan or a line of equity or a line of credit, we have a trust. It's in place. We own it as trustees. Can you, how do you want us to handle that, us owning it as trustees, and make sure that the loan is running to the correct party that the bank knows about? Okay? Yes?
That's already in place. How do you maneuver that into a trust? Before you set up a trust.
The question is about whether you have a loan for business purposes. Okay, but that presumably would be owned. The loan would run to a business. Yes. Okay.
is it secured by your house? Or just a separate? Oh, real estate.
Okay, well, I mean, usually when you have a business loan, you go in for a business, mortgage loan, you're securing it with business property. What usually the lenders that I've worked with, again, the lender requires that the borrower on the loan be Kate Carlisle, the owner of a property that's titled in Kate Carlisle, and sure, I can get the loan and I can use it for my startup, but they require it to be the individual.
But what I was saying, okay, all this, things are already in place. Trust, configuration. So how
Nothing
do
to do with a business loan.
After the fact, get stuff in,
Sure, so after you handle a conveyance, interestingly, pretty much 100% of all mortgage loans on a home have something called a due on sale provision, an acceleration clause. It means you cannot transfer ownership ever, or that whole mortgage will come due and payable. I've never seen it in 20 years, and I've worked with tens of thousands of loans, but I always warn clients. I don't particularly worry with a trust conveyance. So if you own it individually, you have a mortgage loan in place, you come into a trust planner, and now the trust planner is saying, well, let's convey it into the trust, okay? I don't worry, because there's usually a clause in that mortgage that says that you can transfer it if the beneficial interests, ownership, aren't changing. And really, with a revocable living trust, as Laura just explained, you still generally, you own it as trustees, but you're still the beneficial owners. So you don't normally have to get the lender consent to do that. But if you have the ability to tell the lender ahead of time, it's a good idea. Yeah. Yes?
Go into a title company with your full trust. They'll draw up a warranty deed. They might charge you $25, and then like $12 recording with the county, and then you sign it as trustees. You sign it as your individual names, putting it into trustee. It's a 5-minute process.
So I think the comment was that of transferring your property to the trust, right? Yeah, we do it by a deed, and we typically would handle that for you. But the question, I think, is, well, is that going to mess up my loan? And the answer is no. In all the time that I've done it, I've never, like Kate said, it's really transferring the property from you with your individual hat on to you with your trustee hat on. The tax ID number is still your Social Security. And, bankers typically are in the business of loaning money, and they're not going to call due every single loan that's ever transferred to a revocable living trust, because that would be mayhem for them as well. So does that answer folks' questions on that? Right over here.
Moving on.
Excuse me?
I have another question. if
Of
we're
course,
off
I think we're
What are
ready.
the responsibilities in Utah for a trust? So our family is just going through this. My dad lives in New York State. My mother's dad had a trust. He had a 30-page document he had to file with New York State every year to sustain my mother's trust, which had about $400,000 in it. He had access to interest and stuff. But it was costing him $2,500 a year to maintain the documents to file with New York State. And she's been dead 11 years. Is there something similar in Utah?
This woman has a trust for her mother or father? Mother had a trust in New York State that it's been under administration for many years, and apparently something needs to be filed with New York State in order to report on that trust. We have no such thing here in Utah. I'm not familiar with New York law. But in Utah, the trust is a completely private document, which is one reason we like it. You don't have to be in court. You're not reporting to anybody. It's a private document, but it does raise questions. Who are you going to name as your trustee in this document? The word trust is a big part of trustee. And so you want to get somebody, it's a fiduciary role where you want to be able to trust this person, because if you're incapacitated, they take over and they're supposed to use the money for you. And when you pass away, they're supposed to follow all of your directions about distributing that. And so you really have to carefully, and one thing that we do is talk to our clients a lot about who we're going to pick in that position. And what happens if there's a problem. And let me make one more comment, and then we'll go to the question back here. One of the things that Amanda Lambert and there are other organizations here that do this care management where they can come in and advise on medical issues. There's also small companies, sister companies, that will come in and could be the trustee or the agent under your financial power of attorney if you have no one else to name. So there's many people who come to me and say, I don't have family members that I trust, or no one's alive, or they live in, Singapore. Who do I select? Well, there are trustworthy little companies here. There are big banks who will do it as well, but there are also smaller organizations here who are bonded and insured and trustworthy, who can step in and serve as a conservator if you're incapacitated, or to handle your finances, or to be the successor trustee. And so that's one of the things that we plan around disability as well, is who are we going to pick, and do we have anybody who we think can do it? One question back here, and then we'll go here. Hold
Just wondering what the trail would be for who looks after the trustee. Once it's handed to the trustee, who is it that says, wait a minute, is there any such division?
Okay, I'll take this one. You can take the next one. There's a person who looks after the trustee. And so, double-edged sword. The good side of having a trust is you don't have to go into court and have court oversight. The bad part of the trust is if you pick somebody who is dishonest or who has an addiction problem, etc., they might misuse that money, okay? There is no trust police out there to oversee that person. There are ways that if you believe they are stealing, you can go into the court and challenge that person and try to have them removed from that position. But it's a fairly high standard. I had a case recently where we had a trust for an older gentleman who was in California, and the daughter was the trustee of the dad's trust. and she was just taking whatever, borrowing from her father's trust to the tune of $400,000 before it was discovered. And so we moved in to stop the bleeding. We actually were able to have her removed, and now we're in the process of trying to see whether we can get her to pay any of that back, but it's unlikely because, of course, people are stealing because they don't have their own money. So it is a risky proposition, which is one reason why if you don't have a person who you know who can do it, that sometimes these third parties who are bonded and insured, and so if they steal the money, they're covered, you know, and they have an obligation to be that person. And then I'll let you deal with this question.
So if you put, like, say you put your son's name on the trust and you become disabled, but your son passes before you do you have like a secondary person on the trust, like you do with beneficiaries on some of your accounts? You'll have this person and then that person?
So is it a good idea to have a successor trustee? If that first trustee passes away before you, should you have a second? Sure, always. If you have someone that you trust, it's always a good idea to have someone second in line who can step in. Yep.
But it would definitely be only if that other person, your son, say, passed before you. So would two people trying to decide the trust?
Right, so the question is it definitely primary trustee predeceases you? And the answer is that you'd set out multiple rules. So the trustee, it may be that the secondary person steps in when the first person dies. Usually you want to allow some flexibility for if the first person is incapacitated, disabled, and not able to do it. And then third, if they want to resign. If there's something in their life that they can't step in and handle this, you usually want to have that flexibility in place, that they can resign and the second person steps in. Sure, go ahead.
My home residence is Texas. I have property in Utah and I have property in Florida. So to set up a trust, would I have to do it with a Texas lawyer? And in that trust, could I put my Florida properties and my Utah property? And then in the process of setting up a trust, is the cost based on the amount of assets in the trust, or is there a set fee for setting up a trust?
Okay, so the first question is if you didn't use domiciled in a different state, so in Texas, but you have property here and you have property in Florida. So I think as planners, your domicile really is the state that should control the trust law. And that is, I always say, that address that appears on your tax returns. If that's the address on your tax returns, and do you agree with me on that?
Well,
or do you have a different way of looking at that?
Legal minds can.
Yes. Well, yeah.
So I often have clients who have property here in Utah and a second home in Utah, like in Park City. I have clients who come to me, even though they live somewhere else, if they have a significant tie to Utah, like a home in Park City or something, I will do their plan. I mean, maybe the very most conscientious thing would be no, make them go to Texas to do it. However, I have lots of clients who come to me because of my expertise and because they live in Texas and they don't want to do their stuff there because they don't want the people. I have one client who is in Texas who has property in Utah, and she's very high profile in Texas. She doesn't want anybody knowing her business, and she doesn't want to do anything there. She wants to be in Utah. And I accept those kind of cases based on my relationship with those people if they have a significant tie to Utah. So I would first say, yeah, your place of residency, but second, hey, if you're registered part-time, residenced, is that a word? Part-time in Utah, I would do it. I think there was some other.
There was a question about the cost.
I trust, but it's not based on the assets that you are. It's more like the amount of work. And then if you have property in separate states, let's say we do your trust here, what we're going to do is make sure all your other property gets transferred to that trust based on Texas law and New Jersey law, wherever it is those properties are. And so we usually oversee it, but we will find an attorney in each of those jurisdictions who we work with and say, hey, can you help us transfer this property to this trust? How much will it be? And it's usually like $400. And I will do that as a courtesy for lawyers in other states whose clients have property in Utah. At any given time, I'm doing a couple of those. And so we, as full-service attorneys, handle all of that for you by overseeing that other work, because it's so important that those assets get in your trust properly.
Okay, sure, go ahead.
Does the revocable trust deal with the situation of such as with land? You know, while you're still alive, maybe you'll sell it, transfer it, blah, blah, blah. That covers having it, you know, if you named it in a trust, but you're still alive, you can play around with it.
Yeah, so the question is real estate in the trust while so it's titled in the trust while you're alive. How can you control it, and can you control it? And the answer is absolutely. Yes, you have full control over the assets within that trust if it's a revocable living trust.
And the
Just
second
one second.
question, it ties back to what you were talking about earlier. Do you ever advise to have for sort of like a check and balance, that maybe there are true people who are being trustees? Does that help a little bit with the safety issue?
So the question is it a good idea? Joint trustees. So, you know, that is that's another double-edged sword. So the obvious first concern is you have gridlock. You have opposing, right? And you have two people.
Or one lives in Nebraska and one lives in Salt Lake, and now we need their permission on everything. So it's technically a little bit more unwieldy.
Yeah, and you know, I mean, you can set up complicated rules about they can act independently for these types of decisions, but they have to act jointly for these types, kind of like a supermajority. But I find it can be, many people want to do it. I understand that. Many of my clients want to have both the kids, all the kids. But I have found at the other side, the administration side, it's very difficult. Yeah. Yes.
And you move to another state, do you have to redo any portions of the trust?
So the question is, if you live here, is it a good idea to have it revised or redone in a different state, your new state? So again, I mean, I generally say yes, fairly quickly. If your intent is to live in the new jurisdiction, if you move to Maine and you intend to live there and die there and accumulate assets there, I think within a reasonable amount of time, you ought to probably make sure that the laws there, that you ought to get it redone. Do you agree on that?
Yeah, I mean,
Okay.
Trusts are meant to be valid wherever you go in the United States, but each state does sometimes have its peculiarities, and I often advise and you want to, review your plan every couple years. We send letters out to all of our clients every 2 years. You guys have been back in to review and keep everything tight, and so you should be doing that anyways. But if you move to Maine, Maine's going to have a different medical directive, what I passed out for, it's going to look different than Utah's. And so I usually tell clients, hey, you should at least look and see and go get a review every couple years and get yourself a good attorney in that state. Kate and I belong to this very awesome network called Wealth Council, which has qualified estate planning attorneys. We all have the same training, costs good money to be a part of it, and so we're confident that the lawyers in different states who are in Wealth Council are decent to refer to. So if you move to Maine, I would look up on our system and say, oh, here's 2 Wealth Council lawyers in Portland, Maine. You should hook up with one of them. They'll know your software. They'll know exactly how your trust works and have them represent you going forward. Wealth Council, WEALTHCOUNSEL.
Yes.
I'm working
To the differences between these two documents, and I'm real interested in these.
Okay, let's do a couple more questions now, then I'm going to do that. I'll go right. Okay. Do we want to answer a couple quick, and then we'll go to this? Go ahead.
obviously 401k IRAs have beneficiaries and debt can't be put against those. If you put stuff in the trust, can debt be applied to that in a revocable trust?
Okay, question. Your own 401k is not subject to claims by your creditors. However, when you leave that to a kid, it's open to their creditors. The other question was, so if you put your house and other assets of an investment account into a trust, a revocable living trust, are they protected from creditors? And the answer is no. It is not a creditor protective device. It is a device to make sure your wishes are carried out. If you want to protect your assets from creditors, you got to give up control of those assets and put them into a special kind of trust with a third-party trustee and act like you have no control over them. And that gets into a whole nother area. And so the quick answer is no, that's not its purpose. Okay, a couple quick questions, and we're going to do the different.
Going off of what Margie was talking about with her dad having to file paperwork every year because her mother had passed, at what point do you decide, or do you put this into your trust plan, that the trust is no longer going to exist, the assets are going to be exhausted or go somewhere, so that you don't have someone having to deal with this for 30 plus years? Does that make sense?
Yeah, so the question is, when you distribute out from a trust, do you have rules for how quickly that will happen? Stay in place for 30 years. And the answer is yes. However, if you have minor kids or an incapacitated kid, that trust has to stay into effect longer. And so you do have to think carefully about who the trustees are going to be. Like my now 13-year-old autistic nephew. His trust is going to be in effect a lot longer than me and my brother are alive. And so we've got a succession plan for that. Okay, last one here, then we're going to go to the docs. Have a joint revocable trust, does it become with you and like your spouse, does it become irrevocable on the death of the first one? And the answer is it depends on how you set it up. You can do it either way. You can give the surviving spouse the full ability to change it up, but what if they get remarried and decide to give it all to their new spouse? The pool boy or girl, the pool girl. So people set that up different ways. And so it might be that you agree, hey, if one of us dies, we want it to be tighter. We want it to make sure that it doesn't get less chance of it getting siphoned off in a different direction. And so that's one reason why you need to do proper planning and make sure those kind of issues are addressed. I do a trust now that sometimes we say, hey, if I die, my spouse gets remarried, that's okay. But I want him to be, he has to do a prenup before he gets remarried. And we both agree that whoever of us dies first, the new person gets remarried, good for them, but we want this to be protected so it goes down to our kids. And that's the kind of cool planning that we do all the time. So let's stop there and let me go over these two documents and then we'll see if we have time for any other questions. So I think we ran out of the post. There's two documents that I gave you just as an example of something that comes up a lot in questions as we get older. So for medical decisions, particularly end of life, there are two documents that you could be filling out in Utah. Everybody needs one of these, this Utah Advanced Healthcare Directive. We fill these out with our clients. There's some different questions in there. We walk people through it so that they're answered correctly. This form is designed to do two things. Make your medical decisions if you can't speak for yourself. So that could be just you hit your head and somebody's got to admit you to the hospital and consent to run some tests and talk to the doctors on your behalf. And then you're fine again, right? And get your medical records, etc. Consent to a treatment. The other part of it, which is on page 3, is what we call the living will or end of life options, the pull the plug stuff. And so what it says is if you are in a persistent vegetative state or the very late stages of a terminal illness, can you give some directions to your agent, the person you name under this document, as to what you would like in terms of treatment being withdrawn from you? So if I have cancer and I know my diagnosis, but right now if I'm healthy and I'm thinking, oh, well, I don't think I would want to be alive if I was brain dead, you can fill that out kind of in a general sense based on your wishes. So the options are you can leave that decision up to your agents, like your kid or whoever you've named, your spouse, and let them know your wishes. Or option number 3 on there is a little bit more of a forceful option where you could say, look, all things considered, if I'm brain dead or I'm at the late stages of a terminal illness and the doctor says, look, there's not a lot more we can do, if I'm in that situation, I can generally say, hey, let me go home, put me on hospice, don't take me to the emergency room anymore, don't resuscitate me, don't give me antibiotics the next time I get pneumonia, etc. Now, everybody needs one of those. However, it's broad, right? And so it's really hard to capture these very complicated, painful, agonizing decisions in a form that you can get online, okay? We all need them, but it's hard to capture your exact wishes. And then the other thing is your wishes change. As we get older, we might get a little bit, be like, oh, well, I always say this is the Roger Daltrey, the Who song, I hope I die before I get old. But now Roger Daltrey's 75 and he's probably happy he's still alive, right? And so your thoughts change over time as to whether or what you want or not. And so where that pulse, the other document comes in, it's called the Physician's Order for Life-Sustaining Treatment, known as a PULST. That's the other document I gave you. I hate to say, I think we ran out, so if you don't have one, look at your neighbors. Pretty sure you can get this online as well. This is a document that is done when you have a diagnosis for two situations. One is you're older, you're significantly older, and let's say you're going into an assisted living or a nursing home. They will make you fill one of these out. So you're significantly older or you have a diagnosis. So if I get a diagnosis, let's say pancreatic cancer, I'm going to sit down with my doctor. This is a physician's order, which means my doctor signs it. I'm going to sit down with my oncologist and I'm going to go through this document in real time, knowing what I'm facing. So you either fill it out because you're older and you know you're going to die and your life expectancy is no longer super long, or you have a diagnosis. So if I have congestive heart failure, I sit down with my doctor and I know what I'm going to face. And at that point, not broadly, but right based on actual facts, you complete that with your doctor and you get a more precise view and decision about what you do or do not want because you can see what you're facing. And so that's when you fill a PULST out. And it's also sometimes called a DNR, and a lot of times it's blue. And this is what you put on your refrigerator. So if I've got congestive heart failure, I don't feel like going to the ER anymore. I don't want to be revived. And so the next time my neighbor calls 911, they're going to see this. Well, first of all, I don't want them to call 911, but if they do, because I've passed out in the grocery store, if I have that with me or if I am at my house and I have it on the refrigerator, they're not going to revive me, okay? But you got to have this stuff done only when you know what you face. People come in and say, I want to do a pulse. Well, you can't. It doesn't do any good, really, and your doctor's not going to want to do it with you unless it's clear what you're facing.
Should you have multiple copies of this then, like one in your fridge?
Should you have multiple copies of that document? And yes, copies of it. Put on your fridge, keep with you. Go ahead.
Does my advanced healthcare directive from Texas work when I get an accident in Utah and go to the Salt Lake Hospital, or my directives? If my husband has my paperwork or we call up and get it sent, is it still valid?
Are Texas-based documents good in Utah? And the answer is yes. However, this goes back to one question I think might have been yours. If my clients move to Maine, I'm going to suggest that they get a Maine form, because the thing I like to do is when people come to Utah, I'm like, Utah doctors are used to seeing this. They know right where to look. And the Texas one, they might just have to look through and not quite understand it. So I would say have one here and there. Make sure they don't conflict. However, yes, yes.
Something that you don't know in advance. Does the healthcare directive take care of situations like stroke? So you wouldn't, or would you need this just in case?
So the question is, what if you have a stroke and you haven't been able to fill out that post? That's why medical directive. And the medical directive has on page 3, generally, your wishes. And so they would default to this. If you haven't been able to fill out a post, then you still, that's why you have this. And that's why there's some overlap between the medical directive, because it does cover that end of life, and the post. The post tends to be a little bit more specific. Good question.
But if you make out all your paperwork, your trust, will, whatever, and you want your son and your daughter to be the people that inherit everything, or your trustees, is there a way that you can say, I would not like my daughter-in-law or my son-in-law to participate as well? The second part of the question is, can you leave instructions that you want, let's say, your son to inherit, you know, everything you want him to inherit, but not included in his wife's assets? Now, is that against Utah law to do that, or what?
Okay, so the question is, if you don't want your property and possessions through a trust to go to a spouse of a child, if your initial beneficiary is your child, your son, let's say, but you don't want the son's, you know, your daughter-in-law to take. So yes, I mean, you can carefully define who the designated beneficiaries are in the trust. And you can state that upon the death or the passing of your son's share is to go to your grandchildren, let's say, X, Y, and Z. You can do that.
So there's nothing in Utah law, what do they call this?
Oh, so you're talking about, is there anything in Utah law that says you have to benefit one kid over another? That's the beauty of doing your plan, whether it's in a will or a trust. So if you die intestate, which Kate mentioned, which means you die with no plan, then Utah law has rules for where it goes. So that's what you're talking about. So if you died with no plan, but you meant to do one, giving everything to your son, but not your daughter or whatever, but you didn't get around to doing it, Utah law would say, nope, then you just split it equally. And it's got to go through court to do it. But if you do a trust, you can say, yeah, I want my son's share, do this stuff quite often, to go into trust, and I don't want his wife to be able to benefit from it. However, if your son has control over that, he can spend it with his wife. But there are different ways that you can work it to decrease that likelihood. Like Kate said, you can have his trust last for his whole life, and then when he dies, if there's anything left, it goes to his kids, not to his spouse. So there's different ways to handle that. It gets a little tricky. Yeah, we call them the in-laws and we call them the outlaws.
We have here a medical or healthcare power of attorney, but when that comes into effect, shouldn't there also be a regular power of attorney to take care of the other stuff?
Okay, so the question, a different type of a power of attorney other than just health care, and yes, and it's essential. That document is a power of attorney for finances or for money, for assets. And that especially becomes important, right? I mean, if you don't have a trust in place and you become incapacitated, you know, who's going to control the sale of your home or your bank accounts? Well, if you don't have a power of attorney, your loved ones are going to have to go to probate court and have a guardian or a conservator appointed. So the power of attorney for assets works with all the documents. Yep.
And it can be conditional on incapacitated
It can be. It can be it can be a springing power of attorney, which means you execute it now, you appoint your agent now, but it is not used until you're incapacitated. Or, like for instance, many people in the military or that travel overseas want a power of attorney in place now because they know that they're out of town a lot and they want their spouse to be able to use it now. It's a very powerful document. I always tell people it is not the kind of document you make copies of and hand out. You keep that under, in your sealed box and you hold that very carefully because banks really it's susceptible to abuse, for sure.
I think we're out of time.
All right.
Okay.
Just a slightly different part of the phase in preparing to meet with the estate planner. There's some flyers out there. This is a generic form that you can fill out so that you're taking documentation to your wealth advisor or your estate planner about a guide. So it just helps you organize the documents that you might need separate from the kind of forms you passed out today.
I want to thank. We're happy to answer questions up here. John, thank you, and thanks to Steve. We're always happy to come back.